A trade war hits a wall. It's finally happened. In a decision that has sent shockwaves from Washington DC to Beijing and Mexico City, the United States of America Supreme Court just handed down one of the most consequential trade ruling in the American history. Before we proceed further, a word about our sponsor. Let me ask you, are you struggling to find the right solution for your business problems? I would like to introduce HelloGig.com, whose AI engine connects you with top-tier freelancers from your industry only, which helps in designing a better and scalable solution for your business. Whether you are a SaaS startup or an enterprise, HelloGig makes sure that you can focus on your core business. With HelloGig's global freelance network, you can depend upon all your technology needs, be it software development, artificial intelligence, video editing, or even something else. Ready to hire smarter? Scan the QR code given on the screen or click on the link below. Now let's get back to our video. On February 20th, 2026, the landmark case Learning Resource Inc. versus Trump, a 6-3 majority effectively dismantled the centerpiece of administration's global trade strategy. For over a year, the US has been operating under the barrage of the emergency tariff or taxes on everything from Canadian lumber to Chinese electronics, all based on a 1977 law called IEEPA. But the High Court just said stop. Chief Justice John Roberts, leading a surprising coalition of both liberal and conservative justices, ruled that the president simply does not have the power to tax the American people through unilateral tariffs under the guise of an emergency. Today we are breaking down why this happened, the $160 billion refund question, and how the administration is already planning its next move. This is the end of an era of executive power, but as we'll see, the trade war is far from over. To understand why this is a big deal, we have to look at how we got here. In early 2025, the administration invoked the International Emergency Economic Powers Act, IEEPA. They declared their national emergency over drug trafficking and trade deficits, using that as a legal skeleton key to bypass Congress and slaps tariffs of 10 to 50% on nearly every trading partner. Small businesses like, small mom and pop shop and different learning resources and different companies led by Plaintiff Learning Resource Inc. sued. They argued that the tariffs are essentially a tax, and according to Article 1 of the Constitution, only Congress has the power of apply taxes. The government defense was bold. They argued that the word regulate in the IEEPA statute gave the president a blank check to regulate import by taxing them. The Supreme Court didn't buy it. Chief Justice Roberts wrote that while the president can regulate or even block the trade in an emergency, the power to tax is a birthright power of the Congress. He famously noted that the law containing the word regulate and the word importation, but those two words separated by 16 others cannot bear the weight of a multi-billion-dollar tax regime. One of the most fascinating part of this ruling is who's signed on it. We saw Trump-appointees Neil Gorsuch and Amy Coney Barrett join the liberal wing. Why? Because of something called the major question doctrine. The court is increasingly skeptical of alphabet soup, agencies or the executive branch finding massive new power in old vague laws. Majority argued that if the Congress want to give the president the power to fundamentally rewrite American economy through trillions of dollars in tariff, they would have to say that clearly. Since IEEPA, a law used for half a century for sanctions and freezing assets, had never been used to impose broad tariffs until now. The court viewed it as transformative expansion of power that required explicit permission from the Congress. In short, President cannot find a mouse hole in a 1977 law and pull a whole whale of tariff through it. Now, let's talk about the money. Since these tariffs went into effect in 2025, the US government has collected roughly $160 billion in duties. Now that the court has ruled those collections were based on an illegal interpretation of the law, every importer in the country is asking the same question: where is my refund? Justice Barrett in this dissent warned that this is going to be a mess, and here is why. The passing the buck problem, that is number one. Many companies already pass the cost of those tariffs onto you, onto the consumer, by raising the price. Does the company get the refund, or do the customer get the refund? That's a big question. Next is logistics. US Custom and the Border Protection, which is CBP, is currently facing a budget impasse. Processing hundreds of thousands of refunds claimed across thousands of categories of goods could take years. Next, the president's stance. Within hours of the ruling, the president was at the podium saying he hasn't even been discussing refunds. He predicted the government will be in court fighting over these checks for next 5 years. So if you thought this meant the end of the trade war, think again. The administration's response was almost instantaneous. Even though the court closed the IEEPA door, the president immediately signed a new order for 10% global tariff using a different law, Section 122 of the Trade Act of 1974. This law is different. It allows the president to impose tariff up to 15% for 150 days to deal with a large and serious balance of payment deficits. It's a more restrictive tool. It has a time limit and requires specific findings, but it shows the administration's whack-a-mole strategy. When court strikes one down, they find another statuette to use. Additionally, industry-specific tariffs on steel and aluminum, which is Section 232, and the Chinese-specific tariffs, which is Section 301, were not affected by this ruling. Those were done under different law that the court hasn't touched yet. So what is the bottom line? The Supreme Court just reminded the executive branch that the Constitution has a separation of power for a reason. By striking down the IEEPA tariffs, they have likely saved a US household an average of $400 to $600 a year in projected price hike. The average US tariff rate is expected to drop from roughly 17% back down to 9% almost immediately. But for businesses, the uncertainty tax is higher than ever. Supply chains that were being moved to avoid these tariffs might now stay put, only to be hit by the new Section 122 duties in a few months. The tariff man era is entering a new chapter, one that involves more lawyers, more congressional hearings, and lot more paperwork. What do you think? Should the president have the power to act fast on trade during an emergency, or was the Supreme Court right to put the power back in the hands of Congress? Let us know in the comments below, and if you found this breakdown helpful, hit the subscribe button to stay updated on the most important shifts in our world. Thanks for joining live, thanks for watching, and I will see you in the next one. Bye for now.